So our next speaker is Joe Ortega from Nixon Peabody in New York. He is the practice group co-leader of the commercial litigation practice. He's tried over 100 cases to verdict in state and federal court. While Joe himself will deny being a famous lawyer, he does rub elbows with some. He used to work with U.S. Supreme Court Justice Sonia Sotomayor in the Manhattan District Attorney's Office. You may remember in the 1990s a cult classic movie called WarGames, in which a high school student cracked into a military supercomputer and almost started World War III. But what you may not know is that actually kicked off an anti-hacker campaign by criminalizing conduct that was once only punishable by civil proceedings. This resulted in a whole new brand of litigation. Joe is going to discuss in-house counsel's role in protecting personal identifiable information, balancing the benefit to consumers of maintaining big data with the risk of loss and misuse, and a consumer privacy bill of rights and more. Please welcome Joe Ortega.
Well, this ain't Alabama football, but we'll do the best we can. Big data breaches make the news everywhere. We hear the recent stories, we hear about Target, we hear about Home Depot, and if you're sitting out there, you're saying to yourself, not is it going to happen to me? It's not a matter of whether it's going to happen, it's when it's going to happen to one of your companies. And it's kind of scary and frightening out there, and we do the best we can. But you know, when you think of these big cases and you think of Home Depot and these credit card breaches, breaches can occur at your company in many different ways, not just the big publicity ones. Of course, you have the credit card data and the privacy information and financial information about companies. But then you have breaches of your computer system or your IT technology by what I call by employees from hell. You know, those current and former employees that hack into your system. And then you also have it from competitors who you don't even realize at the time they're hacking into your system and they're finding out information and they're competing with you in a very untoward and criminal way. And we think of this, everyone talks about foreign countries like the Chinese trying to raid technology, but I will tell you in this country, your competitors are trying to raid your computer system, your technical information, and there are a lot more people doing this. You can go to the prosecutor's office and ask them. This is not a unique thing. It is happening throughout the country. And what's it costing? The New York State Attorney General did a study, and just in New York alone, it was $2 billion last year in costs to companies from hacking. So you should sit there and be scared, all right? But what are we going to do today? We cannot solve all the problems in 20 minutes on this. I want to focus on the type of breaches that are out there, what kind of breaches that are out there. And if you think that, hey, I'm not a Home Depot, I'm not the Target, I'm not a big financial institution, you're wrong. Smaller companies are getting hacked for different reasons. So we're going to talk about what types of breaches are out there and what options do I have when a breach occurs, and what can I do to protect my client and my company from these breaches? All right, you've done everything right. You have firewalls, you've done encryption, you have the correct encryption, you've shredded all the papers, and guess what? You've been hacked. And you sit there and you say, why me? Maybe it was a former employee, used their old login and got in there. Maybe a competitor somehow was able to access your system, and you sit there and you say, why me? And you start to sulk. Well, as I used to tell my daughters, bad things happen to good people. And this is not the time to sulk. This is the time to get up there and fight, because there are things that you should be doing and you can do when there is a breach. Whether it's a breach from a former employee who went to a new company hacking into your system, or it's someone getting the credit card information from all your customers. You've got to do something about it. And what do you do about it? First things you need to do is you need to contain the breach. And how do you contain the breach? You implement an investigation. And that investigation is you have to determine how the breach took place and what the extent of that breach is. Now, a lot of companies, to surprise me now, don't have a protocol. If I asked you to raise your hands, what's the protocol when there's a security breach or a hacking breach at your company? There are companies that just don't have that. And the time to come up with a protocol is now, not when the breach occurs. And I bring that because who is to blame when the hack comes place? The lawyer. You guys should have warned us. You should have protected us from this. We're always to blame. The outside counsel, in-house counsel, we should have thought about this. We've gone to conferences. We need to do something about it. You got to put someone in charge of the investigation, and that person has to be identified first. And then what do you do next? Do you notify? When do you notify and how do you notify? And you've got to think that out ahead of time. And we'll talk a little about notification, but that should be on your mind, and that should be part of your plan. Second, it's kind of interesting is you got to see whether you have insurance. Cyber insurance has become an extremely popular item for companies that sell and very vital. As a matter of fact, last month, the Senate had 3 separate hearings on cyber insurance because it's a growing area for companies and companies need protection. And some of the cyber insurance comes with someone who comes over to help you to protect your system and to protect you from hacking. Third, is there someone out there that you can indemnify you? Is there someone out there that will be able to indemnify and defend you? That you got to think about. Yes, it is shifting the blame and shifting the responsibility, but you got to think about that. And then I call it, is there a rat in my place? Is there a former or current employee that's responsible for it? Where's the rat? Where's the leak? Do I have a disgruntled employee who's kind of angry at me and did something terrible to me? Or do I have a former employee who's trying to get information and go someplace else? You've got to do that. And you've got to find out how and who to determine what legal rights you have and what you should be doing about this. Legal options. First is notification. And you look at this, it's really not that clear. It is clear in New York, you really go to the states. The states have sort of given you who you have to notify and why you have to notify. If your confidential information is taken, you don't have to notify. If, however, you have personal information from your customers or third parties, you need to notify in New York State. And what do you got to do? First, the lawyer, usually the one who notifies, has to give their name up to the Attorney General and say, I'm the person reporting this leak. Then you have to tell them the categories of information that is missing, and then you've got to tell them the exact information that's missing. And that's in New York, and each state is different on what you have to notify, but not all breaches do you have to notify the government. And in this particular instance, the government is your friend, which is a rarity, and we'll talk a little about that later, but you have to notify. Now, the state government is the person you notify, but what's your remedy? Where is your help? What do you do when this happens to you? When we'll do the disgruntled employee. It's not some organized crime group getting into you, but it's a disgruntled employee or a present employee who gets in there. What do you do? Well, the remedy is federal law. And there's a federal statute that's out there that protects you, that gives you the offensive tool to go after that individual. And it provides for both criminal and civil penalties. And what is it? It is the Computer Fraud and Abuse Act. And like many things that we have out there, it's been in existence since 1986. It's one of those statutes that were out there that nobody ever used, nobody ever cared, and now it's out there, and it's being used to be on the offensive and the defensive for companies that are hacked by their former employees, by their competitors, and that's where really you'll see a lot of it. The big data breaches are traumatic, but it's those competitors and those former and present employees that are getting in. And what does it do? The Act protects computers, certain types of computers. And if you read the statute, almost every server is protected by the Computer Fraud and Abuse Act. So your computer, more likely than not, and your server will be protected by the statute. Great news. It's expanded. And what does it do? It creates liability for what I call for the small stuff, the employee, because you're never going to catch the organized crime that's breaking in, but you're going to catch the employee, you're going to catch the former employee, and you have the ability to catch your competitor who's breaking in. So let me give you an example of a real case that we had. One of the things that intrigued me in New York was, how do you get the electric bill when you're in that big high-rise with all those apartments? Well, I learned that there's a service company that does that, and they have software, and they measure the electricity, and they have that. So let's go into a real case. Tony Soprano works for Meter Company A. Very happy at Company A. Things don't go so well after a while, and he decides that he's going to go. And what he did was he knew all the customers. And what the customers would do at Company A, is they would post all their information on the server of Company A of where their meters were located in the building, where the electronics were, where the software was, and that was the property of the customer. And you would have access to a customer anytime you wanted it, and that's what Company A did. Well, Tony goes to Company B, a new monitoring company, and he's pretty excited about that. And guess what when Tony goes to Company B? Tony goes to Company B, very excited, works there for a year and a half, and of course, everybody loves him, so all the customers want to jump to him, and he doesn't have a non-compete. So, Miguel, you're very happy about that, right? He doesn't have a non-compete, so what does he do? He solicits the customers. He solicits the customers, and that's okay. He can do that. One problem. After he gets the contract from the customer, he says, you know, I need to know where those meters are. I know where to find it. So he goes to the customer and says to the customer, do you mind, you have access to the server where Company A has all your information. I'm going to go log on and find it out. It'll just save me some time. It's public information. Question for us to discuss later. Did Tony commit a crime? And is there any civil liability for Tony and customer B? We'll talk a little about that. Okay, what's the relevant conduct that's covered by the statute? And it's kind of interesting. Accessing a computer without authorization. Anytime you access a computer without authorization, you are now criminally and civilly liable pursuant to the statute. When you exceed your authorized access of a computer, meaning your current employee had access but exceeded what you gave him authority to do or she authority to do, you violated the statute both criminally and civilly. And you cause damage. And we'll talk a little about the elements of what the damage is, but it isn't much. So that's what you do to use this statute. So now all of a sudden you know that Tony has accessed the system. He had permission, I guess. He accesses the system, so what can happen to him? Well, there's civil and criminal. And you now, as counsel for Company A, agitated of Tony's departure, how dare he leave the family, and he is now out there soliciting and hurting you, you now have to avail yourself under the statute. You could now report Tony for both criminal, and you can go after Tony and his company for civil stuff. And there are federal provisions in the statute give you original jurisdiction. You're going right to federal court. And as soon as that complaint is filed, something like the New York Post in New York will put it on the front page. Company B infiltrates Company A, a competitor, because the complaint will be drafted in such a way that it won't be libelous because it'll be in a pleading and everyone will know about your company. And also, what you can do now is you get involved the federal and state prosecutors. They are very excited about the enforcement of this statute. They are your friends. When would the government ever be your friend? But they are now, and you should use them. And they were there to help you. Both the federal and the state prosecutors are excited to do this. They set up units for this. They're ready to chase the villains for you. What is the significance then for us as lawyers? What does this mean? What does this mean? That means that you now have this law in your place and that somebody can harm your computers. You can go after those employees from hell, both former and present employees who've done this. You can now go after your competitors. Because as you all know, a good forensic person can always find out who entered your computer and where they entered it from. So now you can go after them. Defensively, you can also do something. You structure your policies. So your policies are in such a way that the employees know. You train them, yes. You get them involved, but they now know the policies of authorized or unauthorized use. So in reality, when an employee signs that handbook and knows what they can and can't do, they're virtually strictly liable under the statute because ignorance is no longer a defense. They knew they couldn't do something, and they did it. And think about this also. I warn you all, you can never threaten criminal prosecution for civil leverage. But what a better way to have someone have criminal charges pending against them and possibly the company for them to settle a civil suit? Can you think of anything better? And you could think about after the prosecutor gets his conviction, how hard it is to get a civil verdict or summary judgment on what happened there. And it's a very interesting phenomenon because you got the government and Uncle Sam doing your work, chasing people now. What do you need to know in order to do this? All you need is damages of $5,000 in order to qualify under the statute. That constitutes damage. $5,000. You hire a forensic expert to find out who the culprit is, you spend $5,000 the minute they had the first meeting with you. You've got the damages. You have to do it within 2 years of the breach, or what's interesting is, or 2 years within the time that you discover the damages. So this can last for a while. You've got a discovery rule, just like you would have in a tort case. You don't discover the damage, you don't discover the injury, you got 2 years from the discovery. And is your computer protected? You want to play offense with this statute? Yes, your computer is protected because almost every computer is protected under the statute. There are very few exceptions. Okay, what constitutes within authority? There's a split with the circuits. I put it up here. Basically, employees are any improper use by employees is viewed as unauthorized, whether they were authorized to go on the system or not. That's the broad view. So if your employee goes on the system and they, even though they were authorized to go on your system and they did something they weren't supposed to do, pursuant to the guidelines that you put in your policies that you're going to implement, that employee is now liable both criminally and civilly for that. The minority view says that the employee has access. It's got to have some sort of intent or bad intent when they did that. But that is the minority rule, and there's now provisions. The Obama administration has proposed provisions to adopt the broad view. So basically, the employee's on notice. What are some of the places where people have used this? The first case, international airport centers. Basically, an employee installed some sort of device or some software that would delete his emails as they were done afterwards within a certain time period. He leaves the company, going to a competitor, feels a little uncomfortable about that, leaves the software on place. So everything he had done was deleted. That person was found to have violated both criminal and civil sanctions of this statute. He was gone, he was unauthorized, he left it behind, he knew he left it behind, it was. How about this other case, the cultural travel versus Explorer? Basically, this guy was not too great, put a scraper in there so they would be able to get data out, so when he went to the competitor, he'd be able to get pricing data from his former employee. Nothing unusual about that. Should be criminal, should be civil. But guess what happened to the employee? What happened to the employee was that the new company was also found criminally and civilly liable. So it's a little different than your protective covenants. And finally, someone took information, took it home from the computer system, then used it later to start a competitive business. That was unauthorized in both criminal and civil because it was used in an improper way. Defensive uses of the statute, I think it's very interesting. Put your policies and procedures together, get them together, we'll do that, get them going, and you will be protected, and you will catch the rat. The rat will have basically a confession. If you tell the rat he cannot do A, B, and C, he does A, B, and C, it's a confession of judgment or a confession of the crime. That's his own confession. He signed the handbook, he knew he couldn't do it, and he did it. And the case is over. And you should have training of employees. Ignorance is not an excuse of the statute. Hey, the government is your friend. You're going to have investigatory powers. They're going to have more resources than you'll ever have. They'll do that. They'll be able to move forward. And you'll be able to use them and use their resources and use the leverage. What happened to Tony? I'll do it in the bottom line. Tony's thing was innocent. It was public information. It was easy for Tony. Tony was pled guilty because it was a violation of the statute. It's only a misdemeanor now. It's going to become a felony soon. Company and Tony paid out a lot of money for information that was public. And guess what? It put a chill down the other company's back, what they did. So what do we learn from this? I guess I think about it. If your day comes where you have that rogue employee from hell, and if you have your competitor come after you, you have the resources of the government, and you have the resources of the statutes. Don't lay down and say, woe is me, how woe is me. Go out there with a little luck and fight, and you'll win. I wish you the best of luck.